Once you know what the person that you're dealing with cares about, you can tailor your argument. And it might sound perverse, but a well-structured, weak legal argument often does trump a poorly structured, strong legal argument. Today we are going to talk about oral argument, submissions, speaking to a judge, a jury, a tribunal member, and basically what everyone thinks a lawyer does 24/7. It's arguably the most exciting time to be a lawyer when you're on your feet and you're making your case, but it's also the most nerve-wracking. And many great advocates find this to be an incredibly stressful experience, particularly when you're dealing with an unfamiliar jurisdiction. Without going into each and every legal matter type, because there's millions, we could literally make a 2-week video just about motor vehicle claims. It's important to understand that there's a mentality that goes into the preparation of oral argument. And once you master that mentality and you understand this is the best way to do this, and it'll take a while to get there, you will find that things start to get easier. So the first thing that I always suggest with any case is to prepare. You need to prepare. One of the old truisms is that people with money win lawsuits. Well, what does money buy? Money buys time and attention win lawsuits. So it's true. The more money you can throw at a problem, the more you can ask your lawyer to dedicate themselves entirely to it. And that usually will result in a stroke of genius or a flash of greatness. And many cases have been won in that fashion. But putting that to one side, you must prepare. It is so important if you're going to be engaging in any form of oral argument, whether it's a motion, whether it's a mention, whether it's arguing a sentence or trial, to be ready for it. And there's a real importance and a skill to doing the right preparation before your case. There are some lawyers who take the view that, everything settles, there's no point. Well, I'd rather be the lawyer that prepared everything meticulously and yes, didn't get to proceed than the lawyer who didn't prepare and the matter proceeds. So my strong advice is always prepare a matter meticulously and to the best of your abilities. Secondly, and this is one that I use all the time, I start with the end in mind. What is the conclusion I ultimately want the tribunal of fact or the tribunal of law to reach? What is the thing that I want them to take away from the argument that we're having, whether it's in writing or whether it's through a spoken debate? Where do we want to end up? And this is really hard because a lot of people think, well, I want to win. But winning depends on the context. So for example, in a motor vehicle case, winning might be proving that you were not at fault and that the other side owes you money. In a criminal case, it might be proving beyond reasonable doubt that you couldn't have been the one to did it. It could be in a commercial dispute, proving that the contract was valid at the time. There'll usually be 1, 2, at most 3 things that if you get them all right in a row, the tribunal of fact, however that's constituted, is going to side with you. And so it's really important to, before you even do anything else, understand what would those win criteria be. And that brings us to our next point, which is, who is the tribunal of fact? It is a world of difference when you're arguing before a jury versus before a judge versus before a tribunal versus before a magistrate or a mediator. If you're in front of a judge, for example, there is a wealth of information that you can draw upon. You can look at all of their judicial decisions. You can look at the way they've interpreted statutory construction in the past. Are they a black letter lawyer? Are they a federalist lawyer? Are they a lawyer who prefers the spirit of the law to the meaning of the law? And by doing so, you can delve into their psyche, because your job as an advocate is to make it as easy as possible for your client to get the outcome they want. That's all that you want to do. Some judges have a specific way of doing things. Other judges have a different way of doing things. But the more information that you can gather on the person making the decision, the better. For example, in a criminal trial, when your client was speaking, were people rolling their eyes? Were they engaged? Were they in the moment? Did they give off a vibe that they didn't believe them? If so, if credibility is really an issue and you've got 5 or 6 arguments, you might want to make your client's credibility one of the lesser ones and focus on something else. Once you know what the person that you're dealing with cares about, you can tailor your argument. And it might sound perverse, but a well-structured, weak legal argument often does trump a poorly structured, strong legal argument. And we as lawyers know this. That's why we spend so much time on presentation and preparation, because unfortunately, judges can and do get things wrong. Juries get things wrong. Everyone gets things wrong. So you want to make it as easy as possible for the decision maker to side with you. That doesn't mean slamming the table. It doesn't mean becoming overbearing. It is about making the decision as easy as is humanly possible for them to make, and to make it in your favor. So we've prepared, we've started with the end in mind, we know who our decision maker is. Finally, the structure of your argument. And I do this pretty much anytime I go to court. I will, as per step 2, look at what the victory criteria is, and I might make a list. So let's say, for example, in a criminal defense case, I might say, these are the 5 reasons my client couldn't have done it. They have an alibi. They didn't match the description. They were found to be a person of credit. They have no criminal record. There was no conspiracy. There was nothing. There was no motive. There was no mens rea. The crime just doesn't fit. I would then take these 5 and go, okay, I think the fact that they're a person of good, otherwise good character really isn't as relevant. That'll go first. And I think the fact they have an alibi is the most relevant. That'll go last. And I will structure my argument in such a way that I will try to build to a crescendo. I've heard different advocates take different approaches to this. I have found it tends to work for me to build to a crescendo and leave on a high note with the decision maker. But I've heard people say it's the opposite. You start, you get them really interested, and then you kind of layer it through. That'll ultimately be a decision for you. But if you understand what the win criteria is, and what needs to be proven, and you understand what the judicial officer or the audience you're speaking to, then you're going to have a much easier time of this. Some judges are going to very much align with a particular philosophy, and you want to explain why your case theory, when one interprets the facts, most aligns with their philosophy. And that's how you prepare a case. It's a specific type of mindset, and it's a mindset that you can only develop with time. For those of you new to this, please be kind to yourself. I believe truly it takes probably about 20 jury trials before you know exactly what you're doing in the criminal law jurisdiction. And in terms of hearings, you need about 50 to 60. So it does take a little bit of time to get used to it. You are going to bungle things. You are going to make mistakes. You're going to forget evidentiary rulings and rules. But ultimately, it is about really capturing in a very tight compass all of the things that we've discussed to maximize your chance of winning when you go toe-to-toe in oral argument.